I think you can see the presentation. It's a case management ethical practice as a dispute resolution practitioner. Before I go any further, I'd like to acknowledge the traditional owners of Australia and pay my respects to elders past and present. I come to you from the lands of the Gunai-Kurnai people in Gippsland in Victoria, and that's a photo I took just after dawn in Gippsland at the Silk Jetties, which is along river mouth near Sale. For anyone who doesn't know me, I'm Joanne Law. I'd really like it if you use the chat to say hello. And thank you, Ian, for getting that started. Introduce yourself, where you are, what you're doing. That'd be great. Now, with our presentations, we do try and keep them as informal as we can. So if you have any questions as we're going along, please get my attention and we can delve in a little bit deeper, or use the chat if that's more convenient for you. What I wanted to talk about is case management, what regulations and rules apply, what are the risks we need to manage, documents that we need to use, and so on. Basically, case management is a systematic coordination of the processes, information, communication, and documents involved in providing services. As mediators, we have some information that's either prescribed and required under our regulations if you're an FDR practitioner, or expected under the standards if you're an accredited mediator. And they relate to communication, ensuring that we're providing appropriate service delivery, and we're telling clients what we're going to do, and then we're doing what we said we were going to do. And the purpose is to try and ensure that we get good client outcomes and quality services. So if you're in a dispute resolution practice or an organisation, you may not be doing all of the tasks involved in case management yourself. If you're a private practitioner, you very well may be doing everything. How much involvement you've got in creating the individual documents and so on will be based on your particular role. So this little diagram is just, I suppose, looking at the reality of the process, and the attrition may not be 3 out of however many clients that get all the way through the process, but there is always an attrition rate, and that's related to a number of factors. Intake, so those first inquiries, screening, so some cases aren't going to be suitable for mediation, risk assessment, we may get to a point of there, information gathering, some of the people might drop off at that stage, or there may be delays, they're not quite ready, they're going on overseas holidays, they're doing all sorts of things, and then we need to schedule, provide the services and close the case appropriately, and manage the information that we've collected over that. So you should have processes, and if you're working within a group of people, procedures in order to achieve all of those tasks. For those that are family dispute resolution practitioners or on the training, there's some competencies that are expected of you around collaboration, so making sure that your referral processes are in place and you're working collegiately with other services and practices, and the same thing applies if you're nationally accredited as well. Managing risks, case management principles really relate to assessing, planning, monitoring and reviewing to make sure your processes are working, and having processes to make sure that you are doing things consistently. It's particularly important for us as FDR practitioners so that we're providing the same service appropriately adjusted for equity, but pretty much the same service for any clients, and that we're doing our risk management appropriately. We need to think about it in terms of referrals, whether doing a warm referral is appropriate, so basically getting people's information and providing it to another organisation. There's some information in Mediators ethics about not providing referrals to a single individual, making sure that we're giving people choice. But if there's vulnerabilities or particularly special needs where there's a limited range of options, it may be appropriate to do a warm referral. But we need to have a think about that. Is it appropriate? And for FDR's practitioners, inadmissibility important, and there are provisions for ensuring that referrals that we make to other professionals are inadmissible in court. So understanding that, having forms available and so on. Just again, just a high level view of each of the stages that we have. Don't need to dwell on that. So what are our rules? So for mediators, whether you're nationally accredited or training under either NMAS or AMDRAS, the AMDRAS standards are really what's in force at the moment. They will be fully in effect by the 1st of July for anyone who's not currently studying. Once you've completed studies, if you are on the NMAS course, then you apply under the old system and you're immediately nationally accredited under AMDRAS. So those are your rules. And if you haven't had a look at your documentation and procedures, you need to do that. And for anyone who's an FDR practitioner, you'll know that there's been a number of amendments that have come through the system. The final one that's made legislation will come into effect on the 10th of June, and that's going to have particularly impacts on property mediation. There's more changes to practices and processes related to that. The FDR practitioner regulations came into effect on the 1st of April, and so they're fully in effect, and you should have updated your documentation. If not, here's an opportunity to do. Family dispute resolution practitioners, there are some elements of the Federal Circuit and Family Court Act if you're working anywhere other than WA, and the Family Court Act of WA for those who are in that jurisdiction, or if your clients are likely to go to court, that will be the jurisdiction. So that's a question as well. And there are some elements or some protections beyond just the common law protections in the Evidence Act for mediators who aren't FDRPs, but generally we're relying on the convention that mediation is a confidential process. So it's really good to make sure that in your documentation you're reinforcing that with clients and getting them to sign to say that yes, they will keep it confidential and they won't seek to subpoena you to go to court. Privacy Act also does apply to us. We're business people and we're dealing with confidential and private information. So you should have a little bit of an idea of that. And particularly if you are marketing, the sorts of things that you must do in order to allow people to unsubscribe from your lists and other things like that. You should also be aware, if you are working with a service, your internal policies and procedures, your compliance standards, and of course, your code of ethic for your professional associations. If you're a Mediation Institute member, understanding what's in our code of ethics, which is really where, I suppose, trying to articulate the obligations that you have in a hopefully clearer way. But you should have read them and be familiar with them, and just to make sure that you are up to date with what you're doing. Any questions or comments? Is everyone aware that these are the things that are guiding? I suppose we'll have a look at why is case management so important. It's very much around, one, providing good quality service, which is also part of managing our risks, because if we don't provide good quality service, then it creates a risk for complaints and other issues. But the client risks, so the risks that directly affect the client. So these include family violence, so identifying it, providing appropriate resources if necessary, knowing whether or not we should proceed, and personal safety for those that aren't family dispute resolution practitioners. Is it safe for these people to mediate? Mental health issues are certainly an issue. Power imbalances. I'm currently doing my elder mediation training with Dale Bagshaw, and we've been talking a lot about competency. So with older people, if you're doing mediation around that, then you've got issues about whether people are competent and able to make decisions in this process. So there's quite a lot that we need to think about in those regards. So legal risks, they relate to your legal and compliance issues. So they may include being subpoenaed for information. If you're a registered FDR practitioner, that shouldn't happen. If your service is working with non-accredited FDRPs, then there is a risk there if they're not directly working with a registered FDRP, because if information is being provided in the presence of the FDRP, then it's protected. If not, it's not. Also, incorrect documentation, doing things without consent. There's all sorts of legal risks that could expose us as practitioners. Operational risks, so that's the normal inefficiency and missed deadlines, poor documentation, lack of follow-up, lack of handover, all of those sorts of issues. And then reputational risks, the risk to your organisation or your own individual registration from breach of obligations. So as family dispute resolution practitioners or accredited mediators under AMDRAS, we're personally responsible for our actions. It's not the organisation that, or they may also be complicit, but ultimately the buck stops with us. It's not a good enough excuse as a registered practitioner under whichever system. You ultimately have to uphold your ethical standards and, if necessary, push back to your manager or whoever. I'm not trying to create a riot here or insubordination, just very politely point out your obligations and the ethical challenge that you find from instructions that actually aren't correct. If, for example, you've got a manager who isn't aware of those, which can be the thing. So I'm doing a little bit of a compare and contrast here. So with the new regulations, and I'm sorry there's such busy slides, please, if there are any questions as we go, I'm not intending to read every single point, but section 19 says, and for FDRs, you have to uphold reasonable professional standards. It doesn't go into much more detail than that, but you can look to your code of ethics from your professional body about professional standards and the other clauses. So if you're doing all the things that it says you should do, you should be fine. Requirement to assess whether it's appropriate for a person to attend family dispute resolution services. And the same thing for accredited mediators. You've got a requirement to ensure that if the mediation is appropriate. In both cases, it's not absolutely mandated that the dispute resolution practitioner does all of the intake process yourself, but you must make sure that it's being done appropriately and that you get the information. If something bad was to occur and you've just rocked up and you didn't have any access to any of the information where the screening was done and that sort of thing, that wouldn't be a good position for you to be in. Think about the case management processes. So are you getting appropriate report or able to actually access the screening documents or tools that have been used? So it's mandatory under family law, FDR regs, that intake's done, and the information is really only protected by those inadmissibility provisions for registered FDRPs. My recommendation is that you get your agreement to mediate signed nice and early in the process so that people are saying that they won't seek to subpoena the information. And I stress this a lot because it's really important that people are able to be open and upfront with us as mediators. They may not necessarily want to share all of the information with the other party, and if it's not affecting their duty of disclosure, then that's okay. But yeah, if they don't feel that it's safe enough to tell us, then it makes it very hard for us to facilitate an appropriate process. And I've got another screen about all of the list of information that needs to be provided under section 21 for family dispute resolution. In the AMDRAS structure is quite layered, so it's got probably better detail about your obligations in the appendices, and in the body it's got professional skills, and that list is the professional skills that you need to have, and then in the appendices that goes into much more detail. As an accredited mediator, your compliance with any regulation or legal context that you're working in takes precedence over the standards. So if you're working as a conciliator or in a bud service, then the rules and practice standards there take precedence unless they were absolutely unethical, which they shouldn't be. And likewise, if you're an accredited mediator and a family dispute resolution practitioner and you're working in the family law context, then your FDR obligations would be those that apply if there's any conflict between them. So please, if you do have any questions, feel free to ask. Now, these give you a comparison of the information that needs to be provided. Under the new regs, we need to have a statement saying that you're an accredited FDRP. And my recommendation, if you're not a family dispute resolution practitioner and you're working with families in any way that could end up in family court, that you make a positive statement to indicate that you are not a family dispute resolution practitioner, so that it's very clear to them that you haven't got the qualifications and the registration to be that. Clients can't be expected to know whether or not you're qualified in a particular area. The next point is that it's not your role to provide legal advice unless you're a legal practitioner. I'll talk about that a little bit more further on, or it's about procedural matters. So as FDRPs, we're required to provide information about procedural matters, quite a lot of information, and that's expected. With your other mediation, it depends on your style of mediation, how much or how little information you're providing. Encourage you to be careful about that. Ideally provided in documents and information that isn't you interpreting what things mean for the individual people, because then you're really skirting onto providing legal advice. If you're not a lawyer, you shouldn't be doing that. So you shouldn't be interpreting what things mean for their particular situation. You really need to be encouraging them to get professional, independent legal advice. And even if you are a lawyer, it's fraught attempting to provide advice to people that are in conflicts. I'd have a chat with your ethics department for your practitioner registration as a lawyer if you're thinking of going there. If you're an FDRP, you've got to provide people with your confidentiality and disclosure obligations under Family Law Act Section 10H. We can't just say everything's confidential, because it's not. There are situations where we will breach confidentiality. We may or may not tell them that we're going to do it. So if you're saying everything's confidential and then they find out you've made a mandatory report, you've lied to them, basically. So make sure that it's included. The regulations say really this should all be provided in writing. We need to also talk about the inadmissibility protections and exceptions. So the main exception is really if we were asked to provide assistance to an independent children's lawyer if there's no other evidence, but usually that we're not asked or required to provide any further information to a court beyond our Section 60Is or certificate of dispute resolution. And your fees, including your hourly rate for FDR services, and information about your complaints mechanism. So that needs to be provided right up front. Yes, Lara.
John, just a question regarding the inadmissibility, the duty of care and things, because I actually had a phone call from a policeman asking me to make a statement for something that allegedly happened in mediation. It wasn't a breach, but I was then threatened to either make a statement or I get summoned to court, which was delightful.
Yeah.
So say you are summoned to court and you're up on the stand, do you have to say anything, or do you just say this doesn't? Just an example, if you are then summoned and you're on the stand.
Yeah, look, if you do get a subpoena, generally the recommendation would be to write back to the court and say this occurred in family dispute resolution. I'm a family dispute resolution practitioner under Section 10J. They're very sweeping inadmissibility provisions. So it's more likely that the police officer wasn't aware of that.
No, I did end up putting in a formal complaint about him because of the way he spoke to me. So I did email back with 10H and 10J and my obligations, and that the allegation in terms of what you told me does not constitute a breach in mediation. And if there was a breach, then I would have had to disclose that myself. And then I put in a formal complaint just about the way he spoke to me. And then his sergeant got back in touch with me, and they were very good in terms of, no, they just don't understand your role. So I was like, I doubt you speak to a lawyer in the manner you just spoke to me, or expect them to give a statement. So it was dealt with pretty well, but I just still do wonder that what is the differences between what our duty of care is and what police is, because he was alleging a breach, which it wasn't. And the allegation was that Dad said that IVO is just a piece of paper, which perpetrators and victims say all the time. I'm like, that doesn't constitute a breach. If Dad said, I'm going to effing kill you across this table, then obviously that's a different matter. But I just wondered that if you are ever subpoenaed, like, how do you know what constitutes their breach and what our breaches are?
Yeah, so look, if you get to the point of subpoena, your obligation really should be to contest that. If the court ignored it, then again, when you get to court, raise the issue that this is inadmissible and confidential information. And ultimately, if the judge or magistrate insists, you have to oblige. You don't want to get contempt of court or something for someone, but you should be protesting all the way along, because it's really someone who doesn't know what they're doing that's imposing that. Yeah, I've had issues with the same sort of thing. I had a case where a lawyer did a breach application for an intervention, a contravention of an intervention order by inviting her to FDR, which was permitted. I wasn't invited or asked to go to court, but there was a very stern reprimand from the magistrate about putting that as a breach. And we've got a bit of general legal advice in the chat. And yes, it would be proper to object to the subpoena, and then the court would, as you say, there'd be a subpoena objection hearing before just being asked to go on a witness stand. It really shouldn't be happening, but yeah, I was waiting for that to happen and really get a proper case against what we used to have as a precedent, that pre-mediation wasn't confidential, but that's been fixed in this current set of regulations. So we should not have that happening. The other thing that we need to provide as FDRs is a complaints mechanism, and also the information about your FDR provisions. And yeah, so for anyone who's nationally accredited as a mediator, the protections are less clear. They're not legislated in the same way as it is for FDR practitioners. As Ian suggested, make sure that you've got that in your agreement to mediate, so that people don't try and use the information from mediation inappropriately. It's usually regarded as being confidential because it's settlement negotiations and that sort of thing, but it's much better to have it really articulated in your agreements. What's required under the standards is that you provide a description of the dispute resolution process and steps involved. So you should be letting people know your process. So depending on where you are on the spectrum or the range of types of mediation you provide, that should be information that's provided up front. Again, information about how to provide feedback and lodge a formal complaint. And people think, I don't want to, give them ideas. I'm very sorry, but you need to make sure that you've included that in your information. In the members area of Mediation Institute, I've got some clauses there that you might find useful. And you've got a comment, it's confidential save as to a cost argument in a final hearing. Yeah, look, people can make if they do end up in court, they can talk about, these are the offers that I made in mediation, they weren't accepted, and if there's a worse outcome from the litigation, then there may be a cost application as well. So that sort of information, but they wouldn't normally ask the mediator to go along and provide that information. And we wouldn't either provide supporting evidence or deny them the ability to put into their court documents, this is the offer that I made, because they have been made in writing. Got some example documents. If you have a look in the members area in the documents folder, there's some example documents. If you've got a special context, then I think I've talked about that elsewhere. It's a good idea to have maybe a couple of different agreements to mediate based on the type of matters that you're doing. So a workplace context is quite different to contract disputes over large amounts of money. So you might need a much more robust agreement. Good question. Does the liability insurer have any inputs about precedents? I can find out. We've got a collaboration with Aon. They were offering to do a PD for us about matters to do with insurance. Yeah, professional indemnity. Yeah. So that's a good question. They haven't provided us with any, but we can see what we can get out of them from their lawyers. It's a very slow process to get stuff out from their lawyers. And the other elements that I've just bundled in here, there's a lot of information in the AMDRA. It's really a matter of reading through that, but supporting agency and self-determination is really talking about providing accessible information prior to commencement and throughout the process. So if your client's English is a second or fifth language, you need to be thinking about how can you make sure that they're fully aware of the process, particularly knowing that mediation is a term that's used for much more arbitration type process in some parts of the world, making sure that they actually understand what it is that you're going to do. I've had lots of conversations. So I'm a mediator. So you're going to decide? No. My role is to help you exchange information and consider your options and then reach your own decision. Okay, so you won't decide for us? No. And then facilitate a fair process. You're required to provide people with information about the AMDRAS if you're an AMDRAS accredited mediator, and ensure as far as possible that participants understand the process and the substantive matters under consideration. So again, capacity, relative levels of understanding are all aspects. Yeah. So with regards to professional indemnity insurance, even though it's mandated for both FDRPs and mediators, to my knowledge, there haven't been any claims in Australia on professional indemnity insurance for mediators. And that's generally because we have this two-tier system where complaints first go to a complaint handling body who look at the professional obligations, and hopefully you're doing what you should be doing. So it's very different from lawyers who give their insurers plenty of work to do. And that's why the cost of the insurance is vastly different as well. So again, with the AMDRAS, I haven't filled out the full details, but there are requirements around ensuring that it's suitable for mediation in FDR and also that it's a suitable process. With section 22, it's talking about meeting the needs of people accessing services. So whether it's in person or online. So for example, it wouldn't be appropriate for you to issue a Section 60I certificate for someone. You've invited them to mediation in Melbourne, they live in Perth, and you say it has to be in person. If you're not coming, I'm going to issue a certificate. That would be completely inappropriate. If you offered it online and they said, no, fine, issue a certificate. That's one example. I don't know if anyone else can think of others, and of course, the safe delivery of sessions. So someone's indicating that they're really very worried about being in the same room with the other person. You say, oh, no, I like to do all my mediations in person. That may not be appropriate. And if they raise a complaint about that, we'd have to look at, well, were you actually taking into account the needs of the client? So suitability of the process, again, horribly busy slide, but FDRPs, we have to make sure that it's suitable, the time, the delivery manner. And for mediators, we have to determine whether it's suitable. For example, if there's language issues, is an interpreter needed, a co-mediation model? If it's Indigenous Australians that are more traditional, are there other considerations? Could elders be involved? Are there other safeguards needed? Again, making sure that people understand what they're entering into, confidentiality costs and how they're going to be paid. So it's never appropriate for mediation to be conditional on outcomes. That would be highly unethical because it would mean that you've got a vested interest in a specific outcome. No agreement, no pay would be something I'd be very distressed to get a complaint about. And you'd be very distressed at the complaint outcomes. Sometimes we say mediation's voluntary to a point. Family dispute resolution, there's consequences if they don't agree. There may be consequences in other contexts, but mediation can be stopped at any point and the parties can't be made to reach an agreement. So as an FDRP or as a mediator, we need to make sure that people understand that they don't feel like they're trapped, because that could result in our process being coercive. And you also don't have to feel like you're trapped if you think that it's not being an appropriate process, or for any other reason you can end the process. Ideally, tell people, and ideally encourage alternatives. Now, sometimes clients can get quite upset if, as the mediator, you decide that the process has come to an end. So think about how you're going to provide that information without breaching confidentiality. If it's a decision because of the actions or behaviour of one person to the other, you still have to think about how your other obligations apply. Does anyone have any questions or thoughts about that? So let's say someone made a threat or was acting in a way, you may decide that it's appropriate for you to warn the other party for safety, or that you contact the police or other situation. But if it's somewhere lower than that, you may just have to say, no, I just don't find that it's appropriate to continue. Thoughts, comments? No? All good with that? Okay. So this is section 60I. This is just for FDRPs. Again, making sure that your processes are covering this. It can't be issued more than 12 months after the last person attended or attempted to attend. You can't give a certificate A unless you or someone acting for you has at least twice contacted or attempted to contact the party or parties, at least one contact in writing. Again, offering a choice of days and times. So you can't send them a letter saying you must turn up here on this date. That wouldn't be considered appropriate. You need to tell them if they don't attend that you may give a certificate A to the other party, and that the court can take that into account when considering ordering the parties to mediation, and also with cost application. People's failure to engage in mediation can be considered in cost applications. Under the next lot of amendments coming in on the 10th of June, section 117 is going to change to section 114 UB3. So there's another update for your documents because that's mandatory information. The AGs will need to put out another fact sheet about that as well once that comes into effect, and the cascading legislation gets into the FDR regs as well. And we had this come up in a session the other day. Certificate can only be given on behalf of another FDR if one, the FDRP is familiar with the case and the other practitioner is incapable of giving the certificate. So if they've died or uncontactable. For services, really important that you have good quality case files so that another practitioner could familiarise themselves with the case if needed, if a section 60I was requested at a later track after someone has left. And again, for those that are not FDRPs, my encouragement would be just don't work in the family law context because you're not qualified as an FDRP. Not saying that you are isn't really good enough. You need to say that you're not if you are tempted to work in that context. You can't issue section 60I, so if their children are involved in any way, you need to make it very clear to them that you're not. There's very clear obligations under the AMDRAS rules that you need to be very clear to people about your qualifications and experience. So we talked a little bit more about the section 60I in a webinar last week. There's a link to it there and it'll be up in the recorded webinars in the members area. But that one's for avoiding conflict of interest. There's more detail for FDRPs. So the only cases where you'd be able to have previously acted in a professional capacity is as an FDR, previously as a family counsellor. Now that's a family counsellor, not an individual counsellor. You can't go from individually providing counselling to being an FDRP for a couple or as an arbitrator. You've had previous or current commercial dealings or you're a personal acquaintance. So what's required is if you do believe that it's okay to proceed, and if you're working in a regional area, you might be personal acquaintance with most people. So you need to think, firstly, there are commercial dealings or acquaintances, is it going to influence your facilitation? So are you either going to be overly careful in not being biased, so you're actually being detrimental to the person you know, or is there any perception? If not, just refer it off to someone else, don't do it. But if you believe that you can facilitate freely, you need to, in writing, get agreement from all parties. So in writing, that means say what the potential conflict of interest is and get them to sign. So you might have that as part of your agreement to mediate, or you may have a separate document that you get them to sign. So really important. If there's something there, don't just ignore it or brush it aside. Have the conversation. If everyone agrees, get it in writing and signed. The same thing in the Code of Ethics for accredited mediators. It says that potential of a conflict of interest doesn't prevent you completely, but you must have informed consent. So again, my recommendation, if you're accredited mediator, if there's any perception of previous relationship, previous commercial dealings, or if you've acted in a professional capacity, be very sure that you feel like it's not going to affect your facilitation. If so, get it in writing, make sure everyone understands and agrees to proceed on that basis. Questions, comments? So you definitely wouldn't have been a lawyer on this particular issue and then move into being a mediator. You'd refer it off to someone else. There's new regulations around files, and I talked about it more in that other webinar, but we've got to retain our records for at least 24 months. So your agreement to mediate, your intake forms, I would recommend that you do a case summary type document. So you've got the key details about the issues and you can put that on file. And of course, you can't use any information for personal gain. For mediators, it's not as clearly articulated, but my encouragement would be to do something similar. If you have a complaint, it's helpful if you've got copies of those mandatory documents that you've provided. So a signed copy of your agreement to mediate showing that you've provided all the mandatory information, your intake documents and other documents, so that you can show that you've met your obligations, you've done things as you should have. Legal advice, they haven't improved the information on the regs, unfortunately, about legal advice and lawyers. So really, you'll need to think about your other obligations as a lawyer and the challenges. Most lawyers decide that they won't attempt to provide legal advice. You certainly can't provide independent legal advice to people that are in conflict. So it's best to keep it to procedural matters. Although AMDRAS has more guidelines around that, they basically, if you are doing an advisory or an evaluative style mediation, which certainly fits within the spectrum, you've got to obtain consent from the participants. So that goes back to telling people what the process is. So being very clear that your process, you'll provide some evaluation of their cases or whatever it is that you're doing. You must have, within the professional area in which the advice is being given, current knowledge, skills and experience, hold professional registration, membership or statutory employment or the equivalent. This would be, for example, if you're working in a conciliation role or in something where you need to advise people about the legislation that the mediation is diverted from. And you need to be covered by professional indemnity insurance or have statutory immunity. So if you're doing it within the cover of legislation, farm debt mediation, for example, that's fine. If not, this isn't standard mediation insurance. So you'd need to make sure the insurer is aware of the style of mediation you're doing. And I would imagine your fees will be higher. It's not prohibited, but you need to do it very mindfully and very openly. And certainly as an FDRP, we shouldn't be doing that old bush lawyer techniques of, oh no, you're going to get this percentage or that percentage. Lawyers shouldn't be giving a single percentage either, even if it is independent advice, and FDRPs shouldn't be doing that at all. Just some points about the agreement to mediate. It should cover all of your mandatory information, be signed by the parties. You might do it separately just based on logistics. So have the same document, one signs one version of the document, the other signs the other, because ultimately what we're doing is getting an agreement with each party about their conduct and their use of the information shared. So it isn't the same as them signing an agreement that's reached in mediation. The agreement to mediate is actually between us and the party about their conduct, not trying to subpoena us and so on. And again, it should specify that they aren't going to seek to get evidence from this process for the court. You should also be very clear in your agreement about what happens if they do reach agreement and they sign it. So for FDRPs, parenting plans, and we have obligations about providing information about that anyway. And for any other mediation, once they sign it, depending on the type of agreement, it may be a contract. It may even be a contract if they verbally agree, but signing it certainly makes it a lot easier to use it as evidence. And they certainly can be using it as evidence. So make sure you have a pre-mediation tool, whatever type of mediation you're doing, so that you've documented that a proper risk screening and preparation process has been followed. And then there's a whole pile of other documents. We've done some other sessions on some of these in a little bit more detail. Referral networks, having your network set up so you know where. With regards to signatures, electronic signatures are fine. I haven't come across any concerns at all raised by that. Down to people signing it and sending you a photo of their signed signature. The same thing with a parenting plan. You can send it for electronic signature. So I use Adobe Sign and I'll send it to clients in that format. If you're doing in person, then they might sign on the day. But I'm not a big fan of people signing the parenting plan on the day. I think it's good for them to have a little bit of time to think about it, maybe get some advice, because they are committing to a document that will modify the terms of their parenting order if they've got one, and needs to be considered by the court. So it's not just a piece of paper. It's not enforceable, but it modifies the enforceability of orders, which probably costs them a hell of a lot of money to get. And it also is something that the court has to consider. But either way, if you can get them signed electronically or not. With referral apps and sources, because we're now, a lot of us are working online, it's not the same as just having your local referral people that you pop down and you network with. Some of the apps are really useful. Infotech's got Ask Izzy, it's quite a good one. For others, if you've got an app or a website that you use for resources, it'd be great if you could drop it into the chat for others to be able to have a look. The Family Law Advice Line, Legal Aid have got some great resources and information. Some of the community legal services are specialising and have some useful help there. And of course, if you're a nationally accredited mediator and you're getting people coming to you for family law mediation, the FDR register, find a mediator on Mediation Institute. If you've got clients that are in an area that's a bit specialised and that you're not comfortable, maybe you can find someone who wants to co-mediate with you on the network. So have a look at specialisations there. Here's just a pile of resources. I'll make the presentation available for you because we're out of time. And some of the resources for mediators. We won't get time to talk about the levels of accreditation, but we'll do a special webinar on that shortly. We're waiting for approval of alternative pathways for some of these advanced levels, and specialisations haven't come through as yet. MI Events tells you what's on. We also share out other events by providers like the Family Law Pathways Networks and so on. So you can come here and see what's on and click the links to go and register on their websites. And that's it. With a little bit of speed talking, we're finished. So sorry, that was a big information dump. Really, if you haven't done a check against the standards and your documents, it's a really good time to do that now because they came into effect on the 1st of April. So it's actually well past the time. And just flag that you're going to need to update your Section 60I information again the 10th of June once the last lot of amendments come into effect.